Hello, everybody. Welcome. My name is Francisco Servent, founder of Keystone Law Firm, attorney, advisor, author, speaker, all the things. Welcome. Today, we are going to hone in on kind of a limited, call it a case study, limited situation, and I hope drive some details for you all that don't necessarily always come out when we talk more generally about this stuff. So we can really just kind of talk about the specific things that are applicable for somebody in this situation. So welcome. This is the open webinar, and we are happy to do these. We've been doing these now for a while. Myself, my partner, Michelle Dexter, our CFP, Carmi Gutman, and we try to do them about, 3 or 4 times a month. If you haven't seen these before, we've been doing this for over a year now, and we've just got tons of them recorded. And so you can now go back and watch old topics at your own pace, at your own speed. They're on our YouTube channel at youtube.com/Keystone Law Firm. Pretty easy to find. And if you want to register or see what topics we have coming up in the future, we have those posted on our website, keystonelawfirm.com/events. And you can see all the topics, what's coming up, what dates and times they are. Register right there. And it's open to the public. It's, you're welcome to sign up for any of them, all of them. Share them with somebody. If you see a topic and you're like, oh, my golf buddy was just talking about that, and you send it to them, that's fine. We'll welcome anybody to join. The key thing about these being recorded is that they're recorded. So I will have some time before we wrap up the content, before I finish things up towards the end, to deal with questions. I usually don't get to them in the middle, but if you think of a question, you're welcome to drop it in the chat message here, and I'll catch those when we get to the Q&A section. Or I'll open the mics up at that point, and you're free to say, well, I have a question about this, blah, blah, blah. Just know that whatever you say on this is going to be part of the recording. So I don't want you to disclose anything that you wouldn't want posted on YouTube, okay? So if you have a very specific question that feels kind of private and sensitive, save that for a one-on-one conversation, or make it hypothetical, make it general enough so not everybody in the world learns about your private details. I would never want that. So anyway, welcome. We're going to go I've got about 30 or 40 minutes of this stuff, the content, the stuff we're going to talk about today. I'm going to spend a little bit of time also about how we work with clients after we get through the content, doing this stuff for families in Arizona, just so obviously if you want to know how we do things. And that's really the goal with these webinars. The main 2 goals for me, Michelle, Carmi, everybody at the firm is first really that we just share what we know. We've been doing this for so many years, for hundreds and maybe even thousands of families now, that we learn a lot of stuff. And, I'm a much better advisor now than I was when I started in 2007. I've learned new strategies. I've learned new techniques. I've met with so many families, and over the dynamics, you learn when this dynamic comes up, this is probably the kind of solution that's going to work. So we're just better as we go. And so we want to share this information. This is a great way for us to do that. It leverages our time. It gives you the ability to learn from us without having to pay us anything. You just get the benefit of it. So our first goal is really that we share this stuff, and that the people who watch these, you pick up, 1 or 2 nuggets that you didn't know before. And this time was well spent, in my opinion. If you can walk away with 1 or 2 nuggets, you go, oh my gosh, that was a great idea, a great tip. I can take that and do something better in my life with it. And you know what? That's phenomenal for us. We want that kind of reputation. We want to be those kind of people. Our second goal, of course, we are a business. We love working with the clients and the families that we get to work with. And so if you're looking for an advisor or for a firm to help you with any of this kind of stuff, This gives you a very easy way to get to know us a little bit, see the kind of personality we are, see how we do things, how we communicate, how you can see I'm a personable type of guy. I'm not a lawyer in a stuffy suit, right? And if that's what you're looking for, you immediately might not be like, nope, Francisco's not for me. And that's perfectly fine. This is a great opportunity for you to just say, hey, what do they like? Because I'm kind of looking for some help. So that's our second goal. If you're in that spot, great. When I describe how we work with clients, you can learn a little bit about that and see if you want to meet. If that's not you, no pressure. I'm not a high pressure sales tactic kind of guy. That's why I also just have a goal of sharing this information, because if you learn a couple good nuggets out of this, you're going to do better for your family. And for me, that's a win. So let's dig in and dive into our content. Yes, we have to do the lovely legal disclaimer. And just to make sure you all know you can kind of play with the system, Google Meet a little bit. Give me a thumbs up or a comment in the chat if you agree with these main two things. Number one, this is all general information of an educational nature. Okay, everybody, give me some thumbs up, give me an emoji, give me something in the comment box. Perfect. We're getting some stuff. Love it. Love it, love it, love it, love it. Great. All right. So that's the first thing. Second, because this is general information, this is not specific legal or financial or tax or any kind of professional advice for your specific situation. Okay. If you need specific advice, obviously speak with an advisor, get specific advice. We're going to talk about general concepts. I would hate for somebody to take action on this, not knowing how it impacts or affects different aspects of their lives. Like somebody happened to them last year, an advisor said, I'm going to get you this great CD. They did. It came up due, and when it came due, it blew them into the IRMA penalty, and didn't even think of the tax consequences of what that type of investment would do. So take it all into consideration before you take action on anything. So really the first big thing here is, congratulations. Really, if you're in this category, you're at the point where you've built the nest egg and you want to make sure you use it well so that you can live the life and the retirement you've been dreaming of, maybe leave something behind. You are in a category of people who put in the long years of discipline of making sure that how you earned money, spent money, saved money, invested money was done in a disciplined way. It was very intentional. And it's a blessed place to be. Going through those years and all those decades of accumulating, I mean, I'm 46, I'm about to be 47. I haven't done that yet, right? I'm not there, but I've been doing this work for almost 20 years, and I've walked so many families through this process that going from that stage of life into the next stage of life, it is a shift. The shift can feel bigger than a lot of my clients have expected. And so there's you're changing gears. You're going from fourth gear to fifth gear, or fifth to sixth. It's a big shift. And the transitions that should happen aren't always obvious. They're not always so clear, laid out in front of you. Here's the steps. So having that roadmap of what to do now, it's like we've gotten to this point. How do we make sure we don't make a big mistake, something we didn't even think was an issue for the next 10, 20, 30 years? And so I do want to congratulate you. This is a great stopping point to make sure that the decisions you make right now don't end up with a severely negative consequence 5 years, 10 years, or 20 years from now for you, for your surviving spouse, or for your family. So I do want to start with that. When I started out as a young estate planning attorney, I remember the first time I got interested in doing wills and trust was in law school, and I thought, oh, this stuff's really interesting. There's a lot of opportunities and strategies and cool ways to do stuff. I was of the mind, I think I had probably seen some, Hollywood movies and things that, you do your will and you pass away, and then the family gathers around the lawyer's conference room, and the lawyer, reads the will, and there it is, and Susie gets this and Johnny gets that, and the surprise is this, like that's what I was sort of picturing. It's nothing like that anymore. Of course, the world is different. That's not how anything works regarding estate planning or carrying out somebody's affairs. But I understood this was a tough topic. A lot of people are kind of scared to tackle it head on. It feels taboo. It feels like if I talk about it, it's going to happen, and but I wasn't scared of that because I saw how much doing these kinds of things for the people you love the most was really a act of love. It was a really important gift to them. And in a lot of ways, it's your last chance to make a difference in their life and to show them that. And so that's what excited me to get into it. But I was really frustrated that there seemed to be this competition, and in a lot of circumstances, it was this negative type of competition between, the estate planning lawyer and the financial advisor and the CPA and the banker. It's like everybody was just at each other's throats, vying to be the one who had all the knowledge. I'm right and they're wrong, and it felt weird. And then on top of it, what I learned about wills and trusts and the way the industry worked is that it was like you do it and you never hear from the lawyer again. And then 20 years go by and you go, wait a minute, the last time we did this, our kids were minors and we were deciding who to name to raise them if we passed away while they were young. Wait, this doesn't apply anymore. And lawyers just never followed up to check if their clients' lives changed. And that's just not the world we live in anymore. Lives change, laws change, taxes change, the economy changes, the market changes, politics swings. All of those things impact all this stuff. And putting this stuff in place one time, it's obviously critical. But if it doesn't match what happens a year, 5, 10, you now have something that's completely going in the wrong direction. And so early on, very, very early on in my practice, I said, you know what, we're going to do that differently. We're going to get it done right and correctly for our clients, but we're going to make sure we keep this thing up to date, because that, I feel like, is our responsibility as a professional. And so it just is not a set it and forget it thing. And it's a lot like, your car. You can't get it maintained once and say, I'm done. It's a lot like your house. You can't buy it and say, I don't have to do anything to my house ever again. It just does need some at least minimum level of upkeep. And so we're going to talk a little bit about how that impacts what we do here. These are the three big things that I'm going to talk about today. So, and we talk about this a lot, but it's going to be in a very unique and directed concept for you guys, because obviously the laws, they control what can happen. And the laws are maybe 60, 70, 80% of them do stay pretty static from year to year or decade to decade. But it's that 10, 20, 30% that is changing, that if your plan isn't tracking those changes, is that going to create a problem? I met with a family who their mom and dad put together a trust years ago. The dad passed away, and really, really nice family. I think 4 kids maybe. And the mom wants to make some changes, just some slight tweaks, give to charity, things like that. But unknowingly, the trust they set up together years ago has these really convoluted tax strategies in it, like very sophisticated tax strategies that were really, really well done back when they put it together. But those tax laws don't exist anymore. And when I showed her that that's what their trust was, the fact that those existed when he died meant she now has to implement this ridiculously complicated tax strategy that's no longer going to save her any tax money, but it's required, it's mandatory. And it's just frustrating that she has to now deal with all of that. So that's one component of this, is making sure legal is good. Taxes are a big driver of a lot of things these days. And even though the estate tax limit has grown to the exemption has grown to about 14 million per person now, and it doesn't affect most of our clients because you can pass 14 million on for zero estate tax. The changes in the last 10 or 15 years that have happened that affect your estate now are way bigger, and they affect everybody. There's no exemption amount. That have to do with more of your retirement accounts and some annuities. And those taxes can be 30, 40% of those accounts. So tax strategies are a big driver of what we do. And of course, coordinating things, making sure your investments, your real estate, your cars, your bank accounts are all appropriately registered. So we're going to talk about all this today. And I obviously could go on and on and on about this stuff forever, but we're gonna get to it. The shift is from looking at these things as interdependent to completely one thing. That's what I have seen, is that families who look at these as separate but connected end up with actually still a lot of frustrating results for the surviving spouse or for their kids. But families who shift to where this is just all one thing that needs to be solved, they're the ones who have the amazing results. They're if they're married, their surviving spouse has an actual step-by-step solution, who knows why things are going to happen, where things are going to happen. They can see that, well, instead of this, tax bill that just has to be there, they can see there's a bunch of tax dollars freed up or saved and made either your life better or your family's life better. And so that is a shift that I've just seen be really, really amazing over the course of my practice, and really something that we started to implement about 15 years ago. So let's dive into it. So what is the kind of legal plan that somebody who's got a couple $1 million or more needs to set up, or what do I recommend they set up? The first and biggest problem is when you've got a plan, you've got a trust in place, but it's sort of like we don't know how it plays with the rest of our life. A trust itself is only as good as what it's coordinated with. I'm working through a administration right now. Somebody's parent passed away, kind of young, left one child who's a young 20-year-old, had a trust in place. It was updated recently, but the law firm that updated it didn't help with this piece. And so now this person has to go through probate and has to put all this stuff on the public record and has to deal with all the costs and fees and delays of all of that. And also has a whole bunch of debt that is going to be mixed into it because of the fact that there's a probate, when it otherwise could have been protected. Coordinating this stuff is so critical. If you have ever set up a trust, this is honestly the first thing I look at with clients who have some assets to protect. is a really intentional, strategic look at every single thing you have: checking, savings, brokerage, IRAs, annuities, life insurance, cars, real estate, businesses, LLCs, crypto, mineral interests, second home, boats, everything. Doing a really annoying but deep dive audit on that full list and getting paper proof for each one, showing how it's coordinated back to your trust or some part of your plan that's very, very intentional. Without that, it's like buying a car and not putting gas in it. It's not going to go anywhere. So that's our first big thing that I want you to think about. The second thing is specifically for married couples. For married couples, if you've been married a while, or if you're newly married, you should know Arizona is a community property state. As a community property state, there's very specific default rules that say how your property is characterized as community property or separate property. Community property is the default if you don't take very intentional steps to have separate property. There are advantages and disadvantages to both. So it's not all good under one or all bad under the other. It's not. First thing to know about community property: when the first spouse passes away, all of the community property gets a step up in basis. So, as a simple example, if a couple has a house that's worth $800,000 and has investments that are worth $1 million and has IRAs that are worth $1 million, and the first spouse passes away, okay, if the basis of the house was 200,000 and the basis of that stock portfolio was 500,000, the IRA doesn't get the step up, but they have a lot of built-in capital gains. If you sold all of that, there'd be a big capital gains bill. But because if they held it all as community property, the surviving spouse actually gets to reset the basis on the house and the brokerage account way up to the fair market value as of the date of death of the first spouse. That eliminates and wipes out tons of capital gains. A huge tax strategy, but it has to be held as community property. So that's an advantage. A disadvantage is that it's community property. Do you really want it to be community property? Do you want it to be that it's presumptively 50-50 each of yours? You might. If you're a second marriage or a blended family of some type, maybe you want that. Maybe you aren't sure. Be intentional about that, because if the default doesn't apply, I don't want that to control what happens, because a default application of community property is going to end up being very confusing for your heirs, especially if you're in a blended family situation. Those default rules are ugly. They are hideous. Most lawyers don't understand them, and we end up teaching them. So community versus separate. Separate property can have some very positive asset protection tools, where if one spouse is in a car accident and gets sued, separate property might be exempt from that liability. It also might be exempt from one spouse's nursing home bills, things like that. So there are pros and cons to both. Not just doing the default is my goal. I'm not saying one is better than the other. It is very client specific, but making very intentional decisions about the pros and cons of which one fits and which one fits your overall goals is what I'm talking about. A lot of folks are realizing now, with just this humongous push, everything's online now, and then now with AI being able to scrape the internet way faster than any humans could about their information becoming public. And, if you haven't yet, it's an interesting exercise to go to one of the AI things and say, who is this person? And type in your own name and see what they know about you. Keeping your information private, I think, is a valuable exercise, simply because there are all kinds of predators out there. There's all kinds of scam artists out there. And then second, when we do pass away, the less information that is public means the more private what your family members are inheriting. The other advantage to keeping things private is if you do happen to get sued, or somebody's even thinking about suing you, they're probably going to do some research on what do you own, what do you have out there, just to see if it's even worth their time. And if it's hard to find what you own or where you own things or what you have, that can be a big discouraging element for them to be able to even hire a lawyer to go after you. A lawyer's going to say, well, do they have money to collect? And if they can't really find anything worth collecting, it's hard to find a lawyer to take on that kind of case. So keeping things private, where you obviously know what you have, you're in control of everything, and you can use it and do whatever you want with it, but it's not open to the public, is a big goal for clients who have built up some money. The easiest way to do that is with a specialized trust that does keep some anonymity off of the public record. If you really want anonymity, there's a 2-layer system we use that combines either a family limited partnership or a LLC with a specialized trust. And with those, you can almost make it completely blind. So those are tools that anybody can set up, and it doesn't change how you do your tax returns, doesn't change how you spend your money, save it, give it away, use it, but it can remove you from the public records. And the very typical one that we always recommend is when you set up that living trust and you keep it funded, everything in there, it passes things to your heirs without having to file anything in probate court. And the probate court is all public records. And so when someone has to probate mom's house or dad's estate, it all just gets filed there in the public record. And yep, that's exactly how the scammers and insane marketers start just bombarding your survivors with sales calls and solicitations and letters and emails and stuff like that. And it happens. We've unfortunately gotten involved after the fact over the years when a couple clients have been scammed. We had one guy who was actually fell for the Nigerian, I don't know which country, but girlfriend who was able to scam him out of a couple $100,000 over the course of about 6 months. It was a relationship at first, and then it was some money, and then it was some more and some more and some more, and then it was, will you take out a loan to give me some more? And he did. And it happens. As we age, we not only lose a little bit of our ability to really critically think about things, but I also see people get a little embarrassed about that, and so they hide those limitations as they come on, and then we get lonely, and so it's easy to fall into the trap of thinking we're doing something that's okay. There's also a lot of people out there that are just absolute scam artists and will present all kinds of new crypto opportunities and things like that. All of these things, everybody is susceptible to them. And having the right tools in place, specifically a regular trust or one of these anonymous ones, not only will help you do that, but what it also does is it gives permission to your successor trustee to help and help you do this stuff. There's no way to completely protect yourself if you're not willing to ask for some help. And so keeping this stuff in place and keeping it current is the best first way to do it. The other piece before I jump onto the next topic, it's sort of related to keeping things private, but it's to think about how your trust is going to be built, not only for you during your life, but when it's inherited. And so the typical thing that we see when a trust is set up is that it just gives the money to the kids and the money just goes right into their bank account. We wind up their affairs, we pay the bills and taxes and whatever, and we split it up. And here's your check, your check, your check goes into their bank account. Or here's your house and whatever, right? Okay, that's traditional. That's historically what almost everybody did. They would set up their plan and they say, I want it to go to my kids equally, or my spouse first and then my kids. That was just sort of the default. Doing anything more than that used to be really complicated and actually very difficult. About maybe 15 years ago, maybe a little bit longer, Arizona added a whole bunch of new laws that made it drastically easier to give something better than that. And we talk about this a lot with our clients, where instead of just giving them their check, your trust actually gives them their own trust. And what I mean by that, it's not like you're giving them, a trust for your son and his wife to set up their affairs. You're giving them their inheritance, but it's given to them in a way that actually is protected from all these bad things we've been talking about. And it can't be lost in a divorce if they happen to get divorced. It can't be lost if your son gets sued, if your son has to file bankruptcy, if your son is a successful physician and loses a big unfortunate malpractice lawsuit. This is the type of trust that you add into yours so that the inheritance goes into it and your son or daughter can use it. They have permission to use it as you direct, and it could have wide, broad use, almost anything, right? But if they don't, and they just save it and reinvest it and do whatever they want to invest things in there, they could buy real estate portfolio, they could buy stocks, they could do whatever they want to invest it, let it grow. What they leave in there can't be touched by anybody else. So there's no involuntary distributions. It's totally protected. This is something I recommend everybody at this level consider adding, because they can't get this or give this to themselves after they inherit. Only you can put it in your trust for them. It sort of spawns after you pass away, and then it's there for them. Huge advantage. We call these beneficiary protected trusts. Not an industry term, but that's generally what we call them. And then before I move on, there's all the other standard pieces of a trust that need to be part of every plan. You got to have your healthcare directives in place. You got to have your living will that says what medical decisions you want made. You've got to have a durable power of attorney in place that says, hey, if I can't manage my affairs because I'm disabled and I need somebody to help me pay the bills, you've got to have a durable power of attorney in place that says you can access my retirement accounts, you can deal with all the utilities and pay the bills and blah, blah, blah. And there should also be something called a pour-over will. It's a will. You also have your trust, but it's a will that says, hey, if I forgot to title something in my trust when I pass, use the will to put it in my trust so it can follow and get the benefit of all the terms of your trust. We don't want to have to use it because that means you'd be going through probate, but it's there as a safety net. So that pour-over will is there. And then all of the, like we talked about earlier, just as a reminder, every single thing in your life itemized, all your business and financial and asset and account and everything itemized, listed out in painstaking detail with specific instructions on here's how this account is owned. Here's the beneficiary on this account, on this insurance, this life insurance, this annuity, this IRA, this Roth, 401k, just every single thing has very specific instructions. and paper proof that the institution, the bank account, the financial institution, whoever it is, that they've implemented the change you requested. And then real estate, your titles, your deeds are updated appropriately. Your vehicles have something in place, a beneficiary form, a joint ownership, owned by the trust, something, so that it all coordinates back to your legal instructions. What I didn't do, switching to kind of our second topic, what I didn't do at the beginning when I was a younger attorney was deal much with the tax side of things. I wasn't familiar enough with it to really properly advise people, so I didn't. Over the years, I've learned it all. I can't say all, but I've learned enough to know this is actually a bigger driver than some other things. You know, the cost of going through probate, if you don't do all that stuff correctly, might be 10, 20 grand. You know, it might take 12 to 18 months. It's expensive and it's a pain in the butt, but that's sort of a pretty typical scenario. But the cost of getting the tax thing wrong is huge. I remember one of my younger examples was a couple came into me, or sorry, the mom and the two daughters came into me, and mixing them up. Two daughters came into me. Mom was already gone, and said, "Okay, mom passed away. You know, what do we do? Here's what she had. You know, she had a simple will, and like the bank accounts were really small, so didn't need to worry about them because they could just collect them." And mom gave us her house a couple years ago, so we don't have to deal with that. But what do we need to do? And I looked at it and I just immediately knew. And I asked the question again, your mom did what with the house? I said, oh, she quit claimed it to us a couple years ago, so it's already in our name. And I just went, oh, okay, how much is the house worth? And at the time it was worth, I think like 400 something thousand. There was no mortgage on it. And I said, and when did she give it to you? Or no, sorry, when did she buy it? And they're like, oh, she bought it forever ago. You know, they bought this thing. Mom and dad lived there forever, retired there. Like, okay. So they bought it for under $100,000. It was here in Arizona. And I had to tell them that, you know, your mom tried to do something really nice. Like she tried to make this easy for you. So no blame. Like she did what she thought was the best thing to do. Get it in your names and you know, gave you guys the house. What she didn't realize was that by gifting you the house, she created a giant tax bill for you that was totally unnecessary. So she bought the house for 100. The house is now worth 400. So there's a 300,000 gain that when you guys sell this, you're going to pay whatever it was, probably 20%, $60,000 in taxes on the sale. Your mom gave you a $60,000 tax bill, and that was completely avoidable. That was early on. I knew how that tax law worked, and it just drove home for me. I have got to make this a more important part of all my conversations with my clients. $60,000 for a very simple estate. All she had was the house and a few $1,000s in a bank account. $60,000 tax bill. I have another one we're going through right now where it's a snowbird who actually is between Canada and Arizona, and very modest estate. The house is worth about, I think, 600,000. There's a mortgage on it, and completely unknown to the mom who has passed, because of her status as a Canadian citizen and status in the US, her estate is going to pay probably about 120,000 in taxes. Very simple mistake. She had a Canadian lawyer help her do her estate, didn't think about the tax issues. On just that house, it's going to be over a six-figure tax bill. So we decided a long time ago, we're going to start talking about taxes. So putting your trust together is not just putting your trust together. It's also dealing with taxes. If you have any kind of tax deferred retirement account, like an IRA or 401k, those are now some of the biggest tax opportunities that exist because, as you start taking money out of those accounts, every dollar you take out, you're going to be taxed on. And when you hit a certain age, 72, 73, you're forced to take money out through required minimum distributions. All of that is taxable to you, and you're going to pay taxes on it on your tax return every year. What has changed and made this immediately a part of somebody's trust is about, I don't know when this was passed, less than 10 years ago, the Secure Act was put in place, and it changed the tax laws about an IRA or 401k for those who inherit that account. So not necessarily, there were some changes for us while we're alive, but from my perspective, the bigger one was what happens when they inherit it. What does happen is you leave an IRA to your kids, it's now an inherited IRA, and when they take distributions out of it, it is taxable income to them. Okay, so same as you, it's taxable income to you if you take money out, it's taxable income to them if they take money out. The difference now is it has to come out within 10 years. There are some exceptions to the rule, but generally speaking, 10 years from the date of death, it all has to come out. It used to be able to be taken out over the lifetime of your child or the beneficiary, a much longer time period. Most people who are inheriting an IRA, they're in their 40s or 50s, maybe 60s. So they've got 20 or 30 or maybe even longer years. They've got decades to take these distributions out. So when you take out smaller amounts, you keep yourself in a smaller tax bracket, which has a smaller tax impact. When you have to take it all out in 10 years, well, guess what? When are most of the kids in their highest earning years? When they're going to inherit the IRA, most likely, because of, 85 is when the parent passes away and their kids say 30 years younger, they're 55, they're probably in their highest earning years. So they're already in that higher tax bracket. And now they have until they're 65 to withdraw that entire IRA balance, which means pushed into an even higher tax bracket. This is why this is the bigger tax piece for us. And then guess what? There's no exemption here. So it's not as if this only applies to people who have more than $14 million in their IRA. This applies to every single IRA from dollar one. So everybody has to deal with this. It just impacts people like you guys more drastically because if you have larger IRA balances, you're probably investing them well, they're growing, they're going to grow for your lifetime. And then now there's a larger balance that's going to your children in these high earning years, and they're forced to add it to their income every year. So what we add usually, or what we talk about, and we say is an option, there's multiple options, but something to really consider is running the numbers to see if you can stretch that 10 out to 20 years. Because if you have to take out $500,000 over 10 years, that's 50 grand a year. But if you can stretch it to 20 years, that's only 25 grand a year, built in all the other assumptions. But just, that, right? It lowers the amount you have to take each year, which keeps you in a lower tax bracket. So there's strategies to stretch that out from 10 to 20. And you can also look at what we try to look at now is taking those IRAs that you have now and thinking about not just what a Roth conversion would do for you in your retirement. So for the most part, when we run a scenario analysis to see if a Roth conversion makes sense for the client right now for your life, is it going to make your life better? There's almost no scenario I can remember running in the last few years that showed it was worse off for the client. You know, it takes, you have to kind of swallow the tax bill now. I get it. But by investing everything else in the Roth side, you get your distributions for free and you're not forced with RMDs as that account balance grows, because the Roth does not have RMDs. It doesn't have required distributions to you, which means it's not mandatory that you have more income during your life. So there's some dynamic advantages just for your life to doing Roth conversions. Again, run the scenarios, see if it makes sense. The other side of this equation is, how does the Roth conversion that you do during your life impact your beneficiaries? Okay. It can impact them in huge ways. Again, if they take a distribution out of an inherited Roth account, it's not income taxable to them. It's tax free. So all of a sudden now, having to take the distributions out over 10 years is no big deal, because it's not adding to their income when they're in their highest income years. Hallelujah. Right? And during that 10-year period, they can continue to invest and let it grow, because if it grows and they take money out, it's still not more income burden for them. So yeah, the Roth conversion, maybe it does, or maybe it doesn't exactly make complete sense for you during your life, but what if it makes a drastic impact for them? Because guess what? When you inherit an IRA, a traditional IRA, you cannot, tax law does not allow your beneficiaries to do Roth conversions on an inherited IRA. It's stuck. You have frozen it in its place. And so thinking about making those conversions now, for that, there are none of those scenarios we've run that show that's worse off. It's phenomenally better. And so thinking about converting those for your beneficiaries is the big idea for this. It just changes the numbers drastically and significantly. And I don't know if any of you think about tax law right now, but do we think tax rates are going to be higher or lower in the future? I don't know. Give me a thumbs up or thumbs down, or a chat message. I don't know. I don't know how tax rates can go down. I think they're going to go up. There's just, the deficit is growing, everything, right? They've got to catch up with that at some point. So if they're going to be higher in the future, then dealing with and paying the tax on something now is probably going to be at a lower rate than the tax rate in the future. So even that gives us some justification. This is a quick one. Old trusts typically, if they deal with retirement accounts, they say basically the retirement account is inherited to you and straight through to you. You pay the taxes. It's just a shift to thinking about how can we avoid that or reduce those taxes using the trust correctly. And this just talks about that Roth conversion, because the Roths, they don't have these huge tax bills. They avoid it, they save, and they can still be completely asset protected for your beneficiaries. And then switching gears a little bit, the last thing that I want to focus on, and I'm going longer than I thought I was going to, so I apologize. So if you do have questions, start sending them in the chat. The last thing that a trust really needs to have is focused on married couples. And we deal with a lot of married couples. We deal with life partners. We deal with couples who have literally been living together for 30 years, never done the legal thing of getting married, but their whole lives are together. If that's you, if you're in that situation, there's a couple things I want to just make sure you know about, because things are tough if this isn't talked about. First one's not that complicated, but something to make sure you know If you're married filing jointly, remember that when the first of you passes, the survivor is going to end up in the single filer brackets, which are much, much, much lower. And if you haven't done the analysis to say, we're in these tax brackets, we're great. Well, it might mean that your survivor is actually going to be in higher tax brackets when the first of you passes. And that can be a significant reduction in their budget in what they have as far as disposable spending income every month. Doing that number crunching is important ahead of time, because while you're married, you might have options to adjust things and pivot things so that when the first of you passes, some of the survivor's income isn't taxable. And that obviously can help keep those tax burdens down. So that's kind of a simple one. The second one is to make sure that there is a very intentional plan in place with your investments for the survivor so that your survivor isn't forced or already on this rote automatic withdrawal plan from your nest egg that will eat away at your nest egg inappropriately during the market downturns. You know, we always say we want to buy low and sell high. And if one spouse has been doing all that management and coordination, there's always ongoing decisions to make. You want to make sure the spouse understands how, hey, look, we don't just sell a little bit of everything to get our monthly check. You know, we look at the ones that are up, we pick from those, and, you know, that might be where that monthly income comes from. But it's very intentional, because if you're selling across the board or the wrong things when the market is down, you might be unintentionally triggering a inappropriate unbalance across the portfolio, or just losses that you may not want. Those are called sequence of returns. You want to make sure that your distribution plan from your nest egg matches the investment decisions and the portfolio structure, so that you don't eat away at how it's expected to grow, because that growth is what's going to take care of the surviving spouse when they're alone. So that's another one. And then I think the biggest one, maybe the biggest one, is oftentimes one spouse does most of the financial stuff. You know, one of them might take care of the, bills and set up, paying the utilities and things like that. And maybe the other one does all the other things. A lot of times it's one spouse is dealing with the bills and dealing with the finances and dealing with the investments and dealing with the taxes, and really just manages and quarterbacks that whole thing. If that spouse goes first, or their health starts to decline, it's a big project for the other spouse to figure it all out in the midst of that. And I've walked so many widows through this, and it's heartbreaking. The one that sticks out in my mind the most is this couple. They came to me, they'd been married 63 years, and just as sweet as can be, they said, we finally need to get our stuff in order. We got him started, and unexpectedly, he passed 2 weeks later before we did anything, before we got anything done. And so she came back, and we knew he was the one doing all the things. And it literally took us 6 years to wrangle her financial affairs, because he did a great job, but it was all over the place. It was a very, very exhausting process for her. In a married couple, the one who's naturally suited to that stuff, take the lead, run with it, do it, But there has to be a system in place so that there's enough knowledge sharing happening on a consistent basis, and enough tools in place that the survivor can pick it up and say, I at least know where it is, right? I know where to go when I need something. I know who to call for help. I'm not starting from scratch. And even for single folks, right? Your heirs, your beneficiaries are in the same boat. And it happens to us all the time. I'm telling you, all the time, where somebody calls and says, my mom died, my dad died, they had a will, they had a trust, or they didn't. It didn't matter. And we don't even know where to start. We don't know where she banked. We don't know who her financial advisor is. We don't know who her CPA is. We don't know where she has investments. If she has investments, all we know about is where her house is. And then it becomes a game of being private investigator. And it puts such a burden on them. It takes so much time for them to take off of work, be away from their spouse, be away from their kids, up all night going through boxes and files and things like that just to figure out what's the current state of affairs. Having a system in place where this is current is so helpful. When we are named as a client's successor trustee to actually do that stuff for them, we don't just let them put our name in the document. Keystone Law Firm, we don't do that. We require them to build this complete profile out, very thorough, very detailed, and then keep it up to date with them. They must. It's one of our requirements, because we get called on to do the job. We want to know where we're starting, at least that kind of information. And so that's the last biggest piece of this puzzle that I would want to share with you guys. And then just briefly, hope you got a couple good nuggets out of that. How we take care of clients is something we started the first version in 2012 or 2013, where we partnered with a financial planning firm. And then we added tax services to it shortly thereafter. And about, 2022. So gosh, it's almost been 4 years. That version sold and was bought by a larger company, and I restarted the second version, and that's called our retirement management office. And we bring it all in-house here in our office in Chandler. Some of you I recognize on today's webinar, where we do it all in-house. So we have your estate planning attorney, your tax advisor, CPA services, financial advisor, investment management, and you get to kind of approach it as the Mayo Clinic does. You're not having to go to your general doctor to get a referral to a cardiologist who tells you, no, it's actually a cardiac surgeon, and you're just chasing it around. You just get to come to one place and we coordinate it all. And if we say, hey, you should consider this tax strategy, we're not going to tell you, go talk to your CPA to figure that out. Or, hey, we need to make sure these accounts are funded correctly to your trust, and it's registered like this, and it has this beneficiary, and da 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 da. We're just going to do it on your accounts because it's all under one roof. We do that through Keystone Law Firm that does all the legal services and tax returns, and through our financial planning company, Lifestyle Planning, that does tax strategies, wealth management, retirement projections, and investment management itself. All of it coordinated with one team. This is not a fit for everybody, and I'm not suggesting that it is, but some people love it. And the clients who take advantage of it, they feel like they get to finally hand stuff over, and there's finally one spot for all their stuff. If you're curious about this, there is, we do this through an easy kind of first step. It's 2 appointments. There's no cost. As you can tell, my personality, I'm not a high pressure sales tactic kind of guy. It's really for us to figure out if we think we can add value. Most people who come through this 2 appointment process, they're either already working with an advisor somewhere else, and have been for a while, a lot of them, or they're at retirement and it's like all in the 401k and they don't really know what to do. The process is very simple. We do 2 appointments really for us to figure out, can we add value? Are we going to do work that will either take a ton of stuff off your plate or help you find some tax strategies that nobody's even told you about before, or just make things so that it's all in one spot so that it's easy for the 2 spouses or your family when the time comes. at a at a positive return on what you pay us. I mean, the way we do structure this is very similar to other offices, except we just stack on all the services. So we do it with our lifestyle map, where we spot check all these areas of your life. We help you audit, how am I doing in all the areas, not just how's your investment return look. That's one piece. How's the whole thing look? And then help you understand what we would recommend. Like, here's what we would recommend. And that lets you see, do you think we would be a good fit? And if we think we could add value and you think we'd be a good fit for you, then we can talk about partnering together. So again, it's 2 appointments. There's no cost. There's no hard pressure of anything. It's just a discovery of each other, getting to know each other. And we go through the legal audit, the tax analysis, and make sure the assets are aligned with everything. The way we do it is it's just a first quick phone call with me. You don't have to pay anything. You don't have to know anything. You don't have to worry about preparing anything for the meeting. The appointment is online, and it's just a quick 15-minute call where we jump on, you and I, and we talk about what you're doing and what we can do. And if you want to go through the process of discovery between both of us, and we'll create that lifestyle map for you. If you want to grab that time, I just dropped my calendar link into the chat, and you can jump on there and you have access to see when I'm available, when I'm not, and book a time that works for you. I recommend you do it if you feel like some of the stuff we talked about today was valuable and you are interested in having somebody help you implement this stuff. Because I know the knowledge is great, it's wonderful, but if we don't do anything about it, it's not going to really help you or your family. So I'm always here to help us move forward and not procrastinate any of this stuff. I went way longer than I said I would, but I do want to give an opportunity for questions, so I can hang out for a couple more minutes. Is there anybody who wants to drop a question into the chat? Go right ahead. I just gave you the ability to turn on your microphone. If you want to open your mic and ask a question, you're welcome to do that. The other thing that I will put in the chat is our upcoming webinar schedule. KeystoneLawFirm.com/events. You can see that now in the chat, and you can go check that out. The next 5 or 6 of them are posted there, and you can see what the topics are, dates and times. And then I just posted our YouTube channel direct link. Since we post these recordings about a week or so after the date, you will see this one posted. But I recommend, if you want, go there, subscribe, and you'll just get a notification whenever we post a new one. You can be like, oh, what's the topic? You go, no thanks. What I love about the YouTube platform too is you can watch these at a faster speed, so you get all of it, but for you can run it and listen to me talk super fast like an auctioneer. I don't see any questions coming in the chat. I don't see anybody raising their hand or let's see. Okay, we do have a hand raised. Emmett, go ahead and unmute your mic, and you can ask your question. You have to unmute it, though. I can't do that for you. I can't hear you. Emmett. I'll let you try to figure that out, Emmett. Captain Rob, are you trying to ask a question? You're welcome to turn your mic on and ask away if you do. Emmett, if you can't figure out the microphone, maybe you can type into the chat box your question. Nope. All right, look, you're also welcome to send an email, hello@keystonelawfirm.com, and my team will be happy to get back to you. Thanks for coming, everybody. I appreciate everyone being here. I hope you learned something new. I look forward to seeing you in a future one.